Good afternoon. My name is Ben Schwefel. I'm here with John Diley. We're doing today's webinar on tips and tricks for billing practices for new lawyers. We're presenting this on behalf of the California Lawyers Association. It's a nonprofit voluntary bar association. When we split off from the state bar in 2018, it's been formed. CLA has 18 different sections, one of which is the new lawyers section. I'm the education chair for the new lawyers section. And so our goals are we're trying to advance practical skills, pro bono opportunities, networking to new lawyers under 8 years. So this is one of those presentations that we're hoping will continue to further those causes, and keep that in mind. We've got more of those coming up, 1 or 2 a month. We also have, just to overview the new lawyer section, is that we have members at large that we're always looking for, and we also have liaisons to specific sections. So there's a section for trust and estates, a section for employment, environmental law, that each have a representative that goes out. I'm the trust and estates liaison. So those are good opportunities. So if you're interested in that kind of thing, check out the new lawyers section website for those opportunities, and we have an application for that. With that little plug out of the way, then we're going to go ahead and get started, because we got to get talking about billing practices. So today's topic, John is presenting. John is one of the senior partners here at my firm. Really lucky to have John with us. He's been litigating trust and estate lawsuits for about 35 years, let's call it. Lots of high profile cases here in Orange County and throughout Southern California. He's often an expert witness in contested trust and estate matters, and he serves as court-appointed counsel and guardian ad litem, appointed by the court for elder abuse and other trust and probate disputes. So I'm also a trust and estates lawyer by practice here at Murtaugh, Treglia, Stern and Diley. I do a little bit more on the planning and administration side. And so we're going to mostly be covering things that are private client oriented, meaning that people hire us to do work that are private paying, as opposed to insurance company or other fee structure. So we have things about that, but just so you know where John and I come from, we come from a private client background primarily. So we'll be touching on all of them, but in case you have any questions, how something may be different for a private client versus insurance billing.
Or for example, court approved matters, something that may come to court, whether you're representing a trustee and somebody wants to object to it. So you might have court or court staff reviewing billing records and approving them in certain contested matters. So it really depends on who your audience is going to be, and you have to be mindful of that. And just one comment of mine, I'm glad those of you who are taking the time on lunch, we're hopeful to get you something. I mean, you're diligent in doing this. It's probably to some boring. I think Ben was going to talk about not liking to do it, but I think frankly, it's your lifeblood, and I commend you for attending. Hopefully we'll get you some tips and some practices that'll help you be profitable, get the revenue coming in from your clients pleased, and pleasing senior partners who are looking over your billing.
That's right. I know that feeling. So the way that we're structuring this presentation is we're going to go over some general guidelines, things that the rules of professional conduct say about how fees are to be charged and how that influences the way that we do our billing. Then we have 5 core principles, and then some really practical takeaways, which is just us and some of the other partners here having discussions about what clients want, what partners like to see, and hopefully those will be good takeaways. And of course, if you have any questions, you can put it in the chat, or we have our contact information at the end of this slide as well.
Good.
Okay, so general guidelines. This is like a good reference for you to come back. Fees should not be unconscionable or illegal. That's right out of the rule of professional conduct. There's a lot more factors than this second bullet point. I listed a few of them here to determine what is an unconscionable fee, but we've got to look at the value that you're offering in proportion to the amount of fee, the novelty, how difficult it was, the skill, the highly skilled attorneys, like what are you actually performing, whether or not the time that you spent working on one matter precluded you from working on other ones, the sophistication of both the lawyer and the client, and then of course the time and labor required. If you take a look at this rule, you can see there's, I want to say at least another 10 factors or so. We kind of just plucked out the ones that I think, these are the ones that we see day in and day out. And for most new lawyers, I don't think you are in much control of this. You're given an hourly rate by your firm, and you bill, whether you're a small firm, larger firm. But if you're a solo or you're thinking about becoming a solo in the near future, these are the sort of things you've got to take into consideration when you're coming up with your hourly rates and how you're going to bill people.
Well, and yeah, it's essential to your survival, to solo or small firms to be on top of your billing. So it really is, or it's essential for you to succeed in making it up to partner status to demonstrate good billing practices.
Yeah, and I think the last bullet point is just a general observation that we've seen and lots of other practitioners would affirm, which is that one of the most common complaints from clients in fee disputes is that they felt like the amount that they were being billed was unfair. And we're going to talk about how sometimes clients come to that and how what we can do as we enter on a daily or monthly basis. Right. How do we keep them from thinking that something was unfair or unreasonable? So general guidelines continued. So this is an overarching statement I think you need to put in context, right? The attorney-client engagement may be unlike any contract the client has entered into before, and that they want to understand what they're paying for. So what we meant by this was only that at least private clients may have not hired a lawyer before. I mean, we have trustees that we represent, beneficiaries of trust cases that have never even hired a lawyer, and that's really different than when you're working with an insurance company. They know what the relationship is. They may even drive how that relationship looks between the law firms. But a lot of private clients, this is a lot of money. You send them a bill for $10,000 and they've never gotten a bill from anyone that big before. And so you just need to understand that when we enter into these contracts with people to perform legal services, that this is a big deal. And we want to make sure we're giving them a nice diary of what's actually happening.
And a good point at the outset, when you're engaging the clients and you're in this relationship, make sure that your engagement agreement is very clear on your billing practices. You don't have to go into a lot of detail, but I think that's the time when you can lay it out for them. That's the time when they'll agree to it because they want to engage you. And then if something comes up, you can refer back to it, because sometimes, and we'll talk about this down the road, we may, if two attorneys are working on a task together, now in private pay and perhaps insurance defense, they're not going to pay for two attorneys. But if you've got private pay, you may want to have a conference rate where you have two attorneys. We do reduce our hourly rate $100 an hour if you've got two attorneys brainstorming, meeting with the client, strategizing, and it's more the exception to the rule. But lay it out in your engagement letter at the beginning, and you can always refer back to it.
And for a new lawyer, if you're not in charge of the engagement letters, because that's a thing that a partner handles, you should read it anyway. You should go and understand, if it's not in a memo that you received as a new lawyer at the firm, what your minimum billing increments are, the style that there is. There's certain things that the firm wants that is probably mirrored in their engagement letter that they're communicating to the client. This is what we're going to give you. And therefore it's your responsibility as a new lawyer to be putting that down in that form and fashion. So if you've not taken a look at an engagement letter, you should. You'll see minimum billing increments. You'll know what your hourly rate is. You need to be aware of all of those things. Even if you're not the one in charge of it, know what the clients say and what they're going to be expecting to receive. Okay, the second one, your billing entries are a diary of all the tasks you perform for the client. So what's funny is I heard this about 20 minutes ago in our hallway in our office. Yep. Somebody said, oh, even if we're no charging that, it's a diary of what we've done. And I said, that is so good. I'm going to say that in about 20 minutes in this presentation. Yeah. And so, John, you want to kind of unpack some of that?
Billing entries, it's so important, to put time down, even if you're not going to bill it. I think of a tip in my, if I was to offer one, is go ahead and put it down and put a no charge next to it. Pick a few of those that maybe could be smaller, but are appropriately something that, you want them to see that you're doing it, but they see that you're mindful of that in no charging. If you're reviewing a bill, sometimes you're using a paralegal or a secretary. If there's a paralegal task and your engagement provides for billing of paralegal work, then make sure that the paralegal work is, described appropriately as opposed to mere or more secretarial in nature. If it appears secretarial in nature, but you're having a paralegal do it, go ahead and no charge that, because it's usually smaller. But again, this is how you communicate with the client. Hopefully you're keeping them abreast of the cases more often in doing that, but this is what they're looking at. They'll oftentimes look at your opinion letters and they'll go, boy, a lot of legalese, but tell you what, they will scrutinize your bill and look at that. The majority of clients will do that. And I think this is a way for you to communicate with them. So we can talk about the detail in there and formatting and how you do it, but this is you're communicating with the client. How much do you put in a bill, and what you do and how professional you are in doing so.
Yeah, this last bullet point on this slide is something that John and I may not say we don't disagree, because we both agree that this is the thing that keeps the lights on, right? When we bill clients and we send invoices, it's the thing that pays your salary as an attorney. Something that gives you an office that you go and you work in. It pays for other kind of perks that you have. But at the end of the day, it's the lifeblood of the law firm. And so your job as a new lawyer is to enter your time the way that your firm has told you to,
Right.
and to do that. And so some new lawyers, and being in the new lawyer section myself, I can tell you it's not always the most fun task to do, but you have to change your mindset a little bit from, rather than this chore that you're hammering out at the end of the month. That is kind of, people always say it's the worst part about being in private practice. I want to go in-house. I don't have billable hours and I have to enter my time. You just need to change your thought about that.
Well, yeah, I started out running my own law firm, and we, 4 or 5 attorneys at the beginning, but I probably spend more time than most attorneys do reviewing the billings that are going out, because again, this is your communication with the client. I actually like doing billing, because in a sense, and reviewing it carefully, because it allows you to even think about your case. It reminds you where you are and go back and doing certain things, and making sure when you do that, that you use professional terminology you're referring. And I'll tell you, doing it on a regular basis, and especially at the end of the day, I try to keep a contemporaneous notepad next to me where I'm jotting down what I'm doing. And by the end of and I'll look at it before I leave at the end of the day, unless I'm out of the office or something like that, because I can go back and find, geez, I've recorded 4.5 hours, but I was here 7 hours today. What did I do? And I go back and start thinking about it, and I look at what I've got there and I say, oh yeah, I was interrupted and took this call. So I think doing it at the time, and that's actually what you're supposed to be doing, contemporaneous with what you're putting down there. And oftentimes in testimony, you can rely on your custom and practice to do it. But as far as business records, regular, contemporaneous, and describing what you've done.
Yeah, and I think a couple things I'll add to that is, the new lawyer, I think, finds this to be really tedious. And that what you just said about you end your day, you're like, I was here for 9 hours and somehow I only have 4.5.
Yeah.
Well, this is the thing, the new lawyer, right? You have a billable hour requirement, whatever it is, and that you have to meet on a weekly, monthly, annual basis. Your firm is giving you stats about, and I think most of us probably just had a conversation in December about how your last year went. So we were trying to plan this webinar to present some of these tips and tricks, because sometimes that's hard. We're the younger group of attorneys are the most written down attorneys, right? So where the bill is edited down, and it's because there's some of these things that we don't pay attention to, and then the partners say, oh, I can't do that, and then they edit it. So I think the job as a new lawyer is to present our time fully and accurately, but also describing it the way that the firm wants it. If there's an insurance carrier, the way that they want it, that way you can go to the client and have we kind of grease the wheels.
Yeah. And even if you're not reviewing your time, it's going to a senior partner, I think it'd be appropriate to request, do you mind if I take a look at the billing, so I can learn and see how things are being described? Because I've heard situations where the associates just do this work and they never see the bill that goes out. I think it's really helpful to do that. I think it shows that you're thinking from a proprietary interest, trying to figure out how to become profitable. And again, enter all of your time so that people can see, the partners can see where maybe you've spent a little bit too much time. You can have that discussion with them. I remember one thing that I did when I was starting out is I want everybody to think I was smarter than I really was. So I would work for 3 or 4 hours and only write down 2 times. And, I thought that was great, but it didn't let the partner that was reviewing my time see what I did and give me comments and save time. So I put down all your time.
Yeah. So anyway, have that psychological shift of rather than something you have to do that you're dread doing and remind me of this in about 2 weeks when it's the end of the month and I'm entering my time. Think of it as something that we get to do. It's part of the business, and it's the thing when you want a bigger salary, or if there's other things that you want about your career, you want other clients. This is how it happens. It's because we do this essential function of the job.
Okay.
So the next slide, we're going to go through 5 main principles. We're gonna touch on some of the things we talked about in more detail, and then we're going to drill into those and give you some practical examples of how they actually show up on bills and why these things matter. Principle number 1: if you don't record it, it didn't happen. So this kind of goes back to what we were talking about earlier when we said it's a diary. So they may not like getting it from you. However, the more that they understand about what they did, so they read your bill, they see a time entry, and they go, yes, I do remember having that phone call, and Ben said that he was going to prepare that agreement, and then he emailed me the agreement. And they see all of these in this chronological order, they're much less likely to complain about it. They're going to think it's reasonable. They know exactly what you were doing because you were in that conversation with them, and they're just reading a nice history of all the things you told them you would do and that you did do.
Yep.
And so they're more likely to consider those bills to be reasonable and, of course, pay your bill when they do that. I think number 2, this is a good one. The client invoice better not be the only time the client hears from you, or else you will soon have an unhappy client calling John Daly. So, right, this is the idea that if you're billing them for work, and new lawyers could do this, right? Working on discovery, that kind of stuff. You're not in active conversation with the client, especially on legal issues. You need to be communicating with them. And this is your reminder to be doing that more often than every 30 days.
Yeah.
I don't know if, John, you have anything to add on that.
No, I mean, again, the client's looking at this. I mean, timing is everything. They say strike while the iron's hot. I mean, if you've got an event that's come up, or you've just resolved a big case, or you've got something critical that's happened, get a bill out. So just that's the time to do it while they're thinking about it. But again, this is your communication. This is what they're scrutinizing. You better not have typos or anything, or misspellings of your client's name. And sometimes there's a billing department that sends it out. And that's another reason why you want to tell the partner, I'd kind of like to take a look at this. And, if you've got a client that's a doctor, you might want to refer to them as Dr. So-and-so. Use their professional names. But remember, when you're sending out a bill for $5, $10, $15, $20,000, it better look professional, and it looks really bad if you've got typos. It doesn't show you're being very thorough. And this is what the clients are looking at.
And a couple other tips on this too. If you ever go to a mediation, or you're going to John and I were talking about a case right before this started about knowing how much your legal fee is as you walk into that mediation. You can't do that if you didn't enter your time already. So if you don't record it, it didn't happen. And also, if you don't record it, it's not in the system to give you the number. So you may have to go to an accounting department, or you may be able to pull it up through your software. But if you didn't put it in the software, that number isn't counted for yet. And the only thing you're going to do is shortchange either your firm or your client.
Yeah.
And that's going to lead to some unhappy people, either the partners you work for or the client themselves, when you go and ask them to pay and say, I didn't take it into consideration.
Yeah. The other thing is, if you don't record it, didn't happen. On this same thought, this is a time where how much detail do you put into a billing entry? And there's different theories that, you put as little as possible. You don't want to have confidential communications. You might put in less. I think you record your time, and then when you look at your bill, you record it in detail and put perhaps maybe a little more. I use it sometimes because a lot of cases that we're doing are subject to court approval, and you have to go in and you're going to have a court or probate examiner looking over a trust petition, or you're going to have that, and it shows what you've done. You can always edit out and take out of that, but putting more detail in, and especially, and maybe it's later on the slide when we've got an increment. I mean, if you've got research, Ray, breach of fiduciary duty, and you have 8 hours, no, you need to talk a little bit more and break that down. But I think that's moving later in the slide.
Yeah, that's definitely a core principle. The other thing I want to add in here, and new lawyers don't think about this much, and hopefully it's not something any of us have to think about much, but for malpractice issues, right? People can, believe it or not, sue lawyers for malpractice. And one of the things is that if we have a nice contemporaneous record of what we did, when you're asked about this, years, months later, you can go back and refresh your recollection. If you're like me, sometimes that you really struggle to remember everything you did last month, much less something that happened 18 months ago. So it's something that if you're keeping those records, you can reread it and refresh your recollection. And hopefully that's not something we have to come to, but it's good anyway for a number of other reasons. Principle 2, record all of your time honestly and contemporaneously. I'm going to take the first bullet point here because I think this is more me than John. But avoid having to reconstruct your time after the fact. So I'm going to tell you about what I do as a pattern, and then I'll tell you where I could see some improvement. So I have a notepad just like John that sits to the left. I'm left-handed, so it sits right on my pen side of my keyboard, and I take down all the big chunks: telephone conference 1.1 with client, and then I go, that's what I add in. But then sometimes I reach a point where I've got 5.3 hours and I've been here for 8.5, and what happened to it? For me, it's the 0.1s and 0.2s, all the emails, the little conversations with people who have come in and out of my office that I don't immediately type into our system or immediately write down. One of the things that I've done, if I'm taking a call on the road, I'll email myself, hey, telephone conference with client regarding this 0.2, and I email it to myself. So it's in my inbox at the end of the month, and you can ask my spouse, it takes a long time to go back and enter all of those little entries and make sure that you're actually recording all those little bits that have kind of like fallen by the wayside. Yeah. So for me, I wouldn't call that reconstructing time because I do have it down somewhere. It's still very time consuming. Sure. And that is the element of billing that I think most people complain about. So trying to avoid that, I think, is a really good idea.
Yeah, and also having to reconstruct your time. You're doing this contemporaneous, and you can rely on the fact that this is your custom and practice if you're asked to testify about it again. But I find that doing my time right when I'm there, when I've got chunk, I might have a little notepad next to mine where I'll jot down if I stop something and move into something else. But at the end of the day, I make sure all my time is entered unless there's unless I'm out of the office, because it also helps me to structure what I'm going to do for the next day and think about my reprioritizing when I go through all these. And I'll usually pick up another half an hour to an hour of things that I forgot or things that I did, and I'll have my sticky and try and do it then. And then I can go home and let go of it.
That's right.
Okay.
Yeah, and there was a question I saw about, will these slides be available? And yeah, if you shoot me an email after this presentation, I'd be happy to send you a copy of the slides.
And again, the next one talks about record all of your time spent. Just put it all in there and do it, even if you're going to no charge it, even if you know, because it's just, it's really helpful. And it also, the client, when they see a no charge, I get it all the time. Hey, I saw you looked at that, yeah, and this is where we go with oftentimes with paralegal versus secretarial. This was more secretarial nature that should be covered in the overhead. And so this is going to be a no charge. I mean, sometimes it's efficient having my paralegal that's coordinating depositions or scheduling things to have her do that. But I will no charge that time because it's really secretarial nature.
And this is also,
but I put it down there.
Yeah.
Put it down there.
And this is also super important. Even if you're not the one that has authority to decide if something is no charge, you put it down and let the partners decide whether that's no charge or not. For private clients, there's some discretion, but for insurance companies, there's if it's administrative in nature, their billing guideline won't allow it, but it doesn't mean you don't put it down. Again, that needs to be a partner's decision. So record all your time rather than John described when he was a young associate, self-editing. Yep. Don't self-edit. Just put it down, be truthful and honest with what it is.
No, it's a learning experience for you because it's okay to spin your wheels sometimes. You get into it, you're going to do that. It's time well spent, but you may not be able to bill it. And that's the other reason I say, ask the partner, ask who's doing the billing, if you could take a look at it, because you'd like to learn how they're doing that.
And let me add one more thing about the contemporaries. John and I both said we have these notepads, and by no means am I saying that that should be the exclusive way. I'm actually envious of people who immediately enter it into their billing programs. They have the time clocks, and John and I were talking, we have an app on our phone. We can do it through our program as well. And if you're one of those people that can immediately do it that way and you type it in, and you have less people coming and going out of your office. I do it because I can write it down while still talking to someone, as opposed to hold on, I need to type this into the system. But if you're one of those people, I'm envious, keep it up. I think entering it immediately and putting it in yourself, I think
Mhm.
is the best way to capture the accurate description. And maybe our way is slightly less, but also still a good option for people.
It often depends. For me, I have a lot of people coming in and out of my office, asking me questions, this, and it's hard to do it contemporaneously if you do it. And so I'll just put it on a sticky, or I'll ask the associate that comes in, hey, go ahead and bill us on a conference rate. I talked a little bit about that early on. Go ahead and bill our time and make sure that you do that. And then I can move right on to another matter.
Yeah, that's perfect.
Okay.
Okay, principle 3, know your audience. So these go back to some of the things we've already touched on earlier. It was, who is the client? Is it a private client? Is it an insurance company? Is this a contingency fee? Is it a flat fee? That's another one we haven't really touched on, but who is going to receive the thing that you're describing all the work you've done?
Mhm.
I worked at a firm before I joined Murtaugh Traylor Stern Diley about 3 years ago that did a lot of flat fee work. I would say 85% of my work was flat fee. And so we were capturing it not because clients saw the itemized invoice, but because we were capturing it, 1, for malpractice, and 2, to know our efficiency for tasks.
Mhm.
Right, a flat fee is where we say it's going to be $10,000, and the partner who's quoting that fee expects it's going to take a certain amount of time.
Mhm.
And so they're measuring that. And so when we're entering our time, you're still doing it for a specific reason like that. So
Well, there's a couple of reasons. Internally, if you're recording your time and you've got a flat fee of $10,000 and you end up spending $5,000 to get the job done, you've now shown a definite profit margin. They're looking at that, and that's a way to gauge it.
And similarly, if you spend $12,000 on your $10,000 flat fee, maybe something happened that was really out of the ordinary,
Yeah.
that was a one-off, that
Yeah.
we're just going to take the loss and be okay with it.
Yeah.
Or it may say we need to raise our price.
Yeah.
And that has happened. I've seen that happen on flat fees when rates start to increase and all of a sudden your efficiency is down for some reason, and it's a workflow issue.
Yeah. The other thing is flat fees, similar to contingency fees. Do you record your time, keep track of your time on contingency fee cases? Of course, for internal budgeting and performance and productivity and letting the firm know how profitable this particular contingency fee case that you might have to wait 2 years to get paid and run the risk. But also there may be a need for quantum merit recovery. The client subs in another attorney and they go off to trial, and that's on a contingency fee, and you keep track of your time. You can show what you've done and what portion of the contingency fee should be allocated to your firm for the work that you've done and moving the case forward. So again, keep track. I don't know. I mean, I've talked to contingency fee attorneys that love not having to keep track of time, or people that work in-house counsel. But again, it's not that hard to do, and you can get in a habit of doing it.
Mm-hmm. And then I think the last one on here, well, actually, we didn't cover number 2. Are there any special guidelines for billing for this client? So this is one I know just within our firm. My office is physically located next to one of our billing people.
Yeah.
So I hear about this kind of stuff all the time, where whether it's an insurance company or it's a large corporate client, private clients, what I deal with, we have different guidelines, or we have different arrangements with different people for different types of matters. And so there could be a client the firm has had for a really long time and has like a standing, this is our arrangement. And we actually have memos, internal memos, that if you work on those files, that you know that it needs to be entered like this. So as an associate, you need to be aware whether or not one of those exists internally, and whether or not there's things you need to pay attention to. And if you're a solo, you still just need to take into consideration, who is this person? I know we've had clients that they read every single word of that thing, and then they'll find your typos and they'll be like, who is that person? You talk to someone right there. So again, you just got to know. I mean, that's the sort of detail that you're going to be putting into these entries, and know who's reading it.
Yeah. And we'll talk about breaking it down. Yeah, who's reading it? Do you have a beneficiary of a trust who's never had an attorney before, that has no concept of the amount it costs to get into litigation or to provide certain legal services? And so think about them when you're writing your entry in and describing what you're doing. That's going to be read by a layman versus an auditor for an insurance company that's looking for some way they can say, oh, we don't authorize this, we don't pay for this, we don't pay for
or a software program that's going to do it for some insurance companies. The last one on here was just using the right terminology. And this works whether we're sending it to an insurance company, whether we're submitting it to the court for approval. We want to use the right term. I put one that we see in probate all the time, which is defendant versus respondent. We do not call in probate court people plaintiffs and defendants. It's not terminology that we use. And similarly, if you were in civil court, because you're a civil litigation attorney, you would probably not be using petitioner and respondent. So you need to refer to people accurately.
Yeah, and make sure that you've got the professional aspect of it. You're referring to opposing counsel or conference with attorney so-and-so, or meeting with paralegal following court hearing regarding to-do list or action plan or strategy. But record the time, describe your work in professional legal terms, and avoiding first names, things like that. Even if you get to be on a first name basis with your clients and you develop a relationship. This is the profession. You're going to be charging $300, $400, $500, $600, $700 an hour, whatever the number may be. You just have to keep it very, very professional when they're going through it.
So for example, even like if John and I are having a strategy conference, it's strategy conference with attorney Diley Ray, and then we add some description rather than just conference with John, right? They may know who John is, the client, like they absolutely know who the both of us are, but that's how we communicate, and they're going to see dollar values for these things. They also a mediator, there's other people that you may communicate with that's going to generate some sort of invoice back to them. And you need to be referring to all those people.
and even if in fact down the road somebody's going to see your bill, you're representing a trustee gets removed, and now a new trustee comes in and wants to see all the books and records. I mean, there are things that you can do. Or if you're submitting something to court and you have conference with Ben Schwefel, attorney Schwefel, Ray, XYZ, you can redact that oftentimes when there's confidential communications with the client or strategy things. And I'd rather leave it in and redact it than just say conference with Ben Schwefel, Ray case, Ray analysis. Put something in there, and if you need to, if it's ever going to be disclosed for various reasons down the road, you can always redact.
Yeah.
Okay.
All right. So the next one, thou shalt not block bill. So we gave an example of what I mean with block billing, and it'll continue on the next slide. But so block billing in general, it's when a time recorder enters several tasks in one billing entry. So this is a good example, right? You've reviewed discovery responses, apparently performed research and analysis of case law for a motion to compel. Let's put in meet and confer here too. There's probably a meet and confer letter somewhere. You draft a motion to compel further responses. Then you called the client, you talked to them about something, and then you conferenced with your supervising attorney regarding the status of it. 5.7 hours. The client is going to see whatever 5.7 hours times your hourly rate worked out to be. They have no idea whether or not your initial review took 5 minutes or took 3 hours. And so this is an example of an unacceptable block bill. I'm going to skip to the next slide to explain what we would do with an entry like this and how that would be more appropriate. So again, I already described what a block bill is. You just saw an example of one that we would not use. This is never allowed with an insurance company. They never ever allow this to you. And insurance defense litigators, that they just had a heart attack when they saw that slide. And things like travel time, that was not in my motion to compel example, but travel time is always separate. So this last bullet point is what I was saying, how we would edit it. So I have grouped tasks together. So for example, it would be prepared for hearing, attended hearing, memo to client regarding outcome of the hearing, all of those, but I identify how much time is spent for each one of those. So I may prepared for 15 minutes. I just looked over the pleading one more time. I sat there for an hour and 12 minutes waiting to be called. And then I sent an email to the client, hey, the hearing got continued. This is the new hearing date. Here's our next thing that we need to be doing in response. And those are all the same subject matter. So I put those in, but I identify which took what amount of time. You could also, I think, totally okay, put those into separate billing entries. And some of that is your firm's preference for those things, but it can never look like this. You cannot put that on a bill.
Yeah. And one of the other things is, maybe it's just a little pet peeve. I think present tense and active terminology, using an active voice, prepare XYZ as opposed to prepared this. It's almost like you're talking about what you did back then. It's active tense, present tense, prepare this, research this, not researched past tense. But I just kind of a pet peeve. I think it's consistent throughout to go ahead and use the present tense.
And then this last bullet point is something that I think is where people are more prone to put in some block bills, is because they're working on something. It's a big project, opposition to a motion for summary judgment or discovery responses, and there's a lot of them. So they'll start working and there's research and a bunch of things they group together, kind of like this. But you got to come back to it on 3 different days. Let's say you get tired or you get interrupted, you have a meeting because you need to attend a webinar for the new lawyer section on billing, and you put that down and you're going to come back to it again tomorrow. These are some ideas of how you could indicate you started it, you continued preparing it, and then you finalized it. And we gave you a couple ideas of how to indicate with descriptors that progression.
And if you take the time and enter it accurately and spend a little more time when you enter your time, it's going to be easier to go through pre-bills, which we call. But I am also one that goes through my pre-bills, and I think about as if I'm the client reading a pre-bill and what I would like to see, and I'll go ahead and make edits that make it. And sometimes paralegals are entering their time, and you may want to adjust how the description is, so it is more professional, but you can take the time and come back through a pre-bill and do some edits. Then it's going to take more time if you don't enter it as accurately and breaking it down, but I'll even break down pre-bills too, that's for some reason don't have. I wanted to see if you're having a call with them and being very accurate in the phone call where they're on the other line, they know exactly, and as opposed to your research time. So be very careful in going back over.
And then another thing, and I know our insurance people talk about this all the time, they want, when you review or you perform analysis regarding documents, they want you to split it into the document you're reviewing. So where my mind kind of thinks, oh, well, if I read the opposition, I also read the supporting declaration, the separate statement of facts, I reviewed multiple things here. I think most insurance carrier guidelines are going to tell you, you need to have an entry. You reviewed the supporting declaration, 14 pages. You need to give some sort of indication how long it was and how much time you spent on that one document, because they have budgets and they have things, and you need to break it down into those smaller pieces rather than a very general description of reviewed opposition. Probably not sufficient for almost any firm, but something to be aware of.
And sometimes when I'm in court hearings and it could only be a 20-minute argument, oral argument or whatever, or a short period of time, I'll make some entry about that long calendar, end of the calendar, trail to the end of calendar, because sometimes you're there for 2 hours. This is becoming less likely when we're doing a lot of remote appearances, which I think are here for us to stay. But even then, when you're checking in and doing all of that, you may end up spending an hour and a half. And it's good if you're trailed to the end because you have a complicated matter and the judges sometimes to do that. I would make a note of that in there. And it also comes back to you. And if the court's reviewing it, they say, why you've got a 3-hour court appearances when it was a trial setting conference or a 2.5 hour. And it's because I was number 38 on the calendar. And so again, it's something that you can come back and be a reminder to you if you're doing a fee declaration or addressing concerns that the client may have.
Absolutely. All right. Principle number 5, the more time spent, the longer the entry should be. So we're probably going to talk about a few of these. So I put in some notable exceptions, and these are ones like you're driving to a location. For me, downtown LA. I was telling John I went for the first time in 3 years to Stanley Mosque for a probate matter, and it was raining. And in Southern California, rain, traffic, people, it was bad. Took a long time. And so, but on the way back, it was 11 a.m. There was no traffic and the rain had stopped. A dramatically different time. So the time entry, the same, travel to or travel from. However, one was significantly longer. So I don't need a really long description to say, drove in terrible traffic in the rain to Stanley Mosque Courthouse. So that would be one exception. And mediation's another one. And I know John does mediation entries, sometimes a little bit more substantive, but it could be prepared for an attended mediation. You could be there for 12 hours.
Yeah, I might reference with Judge so-and-so or retired so-and-so, opposing counsel and parties. Again, if you've got a 12-hour entry for a mediation, having a little bit more mentioning who was there and doing something like that. And oftentimes I'll say, when I put that, including travel time at a reduced rate. Sometimes I'll try bill half of it. Some people it's portal to portal. in doing that, but, reference that a portion of it is travel, and you can even indicate that an hour and a half of it was travel time so that they understand. In any event.
Yeah. Okay, this is a real practical one, and maybe your firm has something like this, but if something takes longer than average, so longer than it should, and maybe your partner can give you some guidance on how long something should take, or it's longer than a half hour, you got to give some sub descriptors and quantitative values. So I gave an example here. There are lots of form interrogatories, and then 17.1 alone was 15 pages long. So as you're doing analysis for that, you need to be saying the reason it took me so stinking long is because one answer was 15 pages and I had to review it and pick it all apart. So that is a way to describe to the client the reason that there's such a large entry with such a large dollar value over here to the right on the bill is because this one was 15 pages long. So you've got to start giving more descriptors like that. So one of the things that we have as some examples in one of our memos is you can do an analysis of some notice, and it's a 0.1. The notice that you receive can have a really long title. The other option, the other thing you could do is you could be doing analysis of a motion that was 257 pages long. That's a dramatically different time entry, and it's going to take a dramatically different amount of time for you to do. So you should be telling the client, this is why it took so long. Right? That's basically what you're telling them.
Yeah. Another thought too is in some firms I know have minimum increments, 0.2, 0.25. Frankly, I don't like that. I don't do that. And I think clients like to see if you've got a 0.1 here or there throughout the bill, they see that, a correspondence comes in and you review it and then give it to your paralegal with a memo to what to do with it. And it's a 0.1. I think they like seeing that, and it shows them that you're really looking at, in 6-minute increments, 0.1, 0.2. But I think having those throughout your billing is also something that is good for client relations.
And earlier I gave an example of initial, further, and kind of finalized when you're doing things on different days. I think it's also fair to, if you're going to spend a lot of time, let's say you did a lot of case research on a really novel issue for a motion for summary judgment, and then you drafted part of the motion, you just have to give descriptions about what part was taking so long, right? So let's assume John and I are just having a strategy conference in John's office about this issue. And I said, there's this, I know they attacked it on these 5, these 4 don't take very long. This one though, I don't know if it's a winner. Let's talk about it. And it's one that I spent a lot of time researching. When you're communicating that to the client and to the senior partner reviewing the bill, they need to know why of the 5 issues, why one was so different than the other. So take into account which piece you're doing. Is it the declaration of the expert? And so you're having to have conferences with an expert that supports your motion. Is it a declaration that was largely drafted for the client by you because you already know those facts, and so you just put it together for them? You've got to give some indications and how long it's going to be.
Well, it comes back to that first point that we mentioned when we started. Your bill has to be fair and reasonable. How can you evaluate its fairness or its reasonableness if you don't break it down? How's the client going to be able to understand it if you don't break it down in increments related to specific projects? I think it's extremely helpful.
Yeah. All right. So this last one, and this would be a good time if you start having questions, we said something and you just want to throw it out. John and I just put together a bunch of things that we probably even have more that don't fit on this slide. Things that we either are talking about with junior attorneys here that we have run into. And these are things that either we came up with or our partners and other attorneys have come up with. So this one, in private practice, you may never love recording your billing. That's from me. John's is you will love your recording your billing.
Well, you will learn. It'll educate you. I mean, it's part of the practice. It's part of, and starting out when you're running your own firm, if you're starting out in a small firm, this is where you make your money. And the clients will call, and if they want a question, the more you have accurate billing, the less you're going to spend time discussing your billing with your clients, which you can't bill for. So I frankly, starting my own firm, it was extremely helpful to spend the time, and I actually enjoyed it. And I was thinking what I would like to see if a client's there. Obviously, it's accurate about what you do, but it shows you put some thought into it, and it's a good, and again, establishes good habits, and again, it's something you can rely on. If you have a practice of doing something, and you're asked about a bill or something 5 years later or something along those lines, you can go back and say, well, my custom and practices, and based on my custom and practice of doing this, I would have recorded this at or about the time. And I always go in this level of detail. So if it's not there, it's not something I, forgot to put in or didn't put in. It's just consistent with the custom that you've used.
Yeah, and I think that establish good habits and be consistent. This is totally variable depending on which sort of firm you work at. Is it a private client? Is it insurance? Is it contingency, flat fee? So only you know what this means for you, but figure out a good habit so you don't dread this part of your life. So your significant other doesn't really hate that period of time. I know I've been on vacation entering time before, and my wife said, "Why didn't you do this before you left?" So that I would not recommend doing that. I would recommend establishing a habit, being consistent in that habit. And that way, over the course of your long career as a lawyer, this is not something that you dread, but something that you come to realize is a very valuable tool for communication between you and your clients. And of course, the thing that makes our practice go round and round. Heed the feedback from your partners, clients, and make adjustments.
Okay.
So this is easy. John gives me tips on how to do billing, just like this webinar. So I try to adopt those for the next month. So when there's a client that John and I are working on together, John's not telling me, hey, the same thing is on the bill this month. Either I've edited it or I've entered it differently this time.
Yeah. Heeding the feedback from your clients. And I think that's something I've always told the clients at the beginning, look at, this is new to you. This is something a little different. If you have any questions about my billing, please give me a call. I'm happy to talk with you about it. There won't be any charge. I don't have traditionally, very, very rare do I have any type of fee disputes with the client. And if the client sees something and you look at it, gosh, I missed that. You make a good point. Let me see, I'm going to do maybe a courtesy adjustment and talk to them about that. That goes a long way. And you try and do it efficiently. And, you'd spend 10 or 15 minutes on the phone, not any longer, but you talk with them about it, give them the discount, and just they appreciate it. They know you're listening to them, and you can educate them a little bit. And you can also use that to educate them about how they're spending too much time on the phone with you. And you say, look, I think we've covered it. I'm mindful of the most efficient way to get this done. And so that also can help you to manage the client's expectations, know that they're being heard. And again, think about it. Is this somebody right at the beginning that's asking you questions about your bill? Your first invoice that goes out, they've got a question about this or this or this. Maybe that's giving you an indication about the type of client. If it's somebody that's been with you for a year or two and paid you several $100,000 in fees, and you've got a question, you just absolutely go along with what they do. It's just worth it. It's much better. And in the long run, you may have to explain it to your senior partner or why you're doing it, or to your other equity partners of why you're doing this, but then you can show them, here's the bottom line, and we don't have disputes.
And I would add, even if you're not the decision maker, so even if you're the associate and you're not allowed to make decisions like that, it's really helpful to know. So for example, we come across bills where it's a junior associate or a paralegal or something, and you see the time entry and you're like, we cannot bill them for that. But I never, as an associate, found it super helpful to not be aware of that. I appreciated knowing, that was too much. I can't pass that along, because not that I should self-edit my billing entry, but well, here's why it took so long. And then the partner says, I know, but you didn't communicate that in your billing entry.
Yeah.
And so it's really helpful. It helps me learn how to do that. So when you're having those conversations with a partner, even if you're not the decision maker, pay attention to what they're saying, and that way you can improve it.
And it's assignment. You can sit down with the billing partner and suggest, when I got this assignment, you didn't give me this. You thought this assignment was, maybe a 3 to 5 hour assignment. Really, it's a 10-hour assignment if you want to do this or this or this. Did I mishear it? Did I go off on a tangent? It's a good conversation to have. It's an education. It's learning for you. And again, billing is it's the blood of the practice. It's how you keep it. Keep your firm going, keep your, it's just an integral part of the practice.
And quick tip, if that happens where a billing partner thought it was going to take 3 hours and it takes you 10, don't tell them after you've incurred 10. Tell them before you got to 3 and you got into it and realized it's a whole different beast, and then go back to them. talking from personal experience. Okay, so the next one I mentioned are the sooner you enter all your small entries, the 0.1s, 0.2s, whatever your minimum increment is, the better off you'll be at the end of the month. You will not be going through your inbox or your sent emails or sticky notes that you stuffed in your moleskin that you carry around with you. But these are the ones that to me are like the little paper cuts. At the end, they're bitter as you enter them and you're trying to track them all down. I know I did that. Oh, here's the 6 emails I sent and I never wrote down. If you can just do those, you'll enjoy, I think, this process a lot more and find it to be educational and valuable.
And if you have your little pad next to your phone or whatever, and you just do case name, 0.1, TCW, telephone conference with, and then move on, and then you come back at the end of the day, you can add to that and put a little substance in and do that. And again, it's a good way to finish off your day.
Mm-hmm. And this last one, know your firm's guidelines, rules, and deadlines and abide by them. I'm going to say that some of this is because I'm sitting next to the billing person. So I know those deadlines, but these can be things like the firm may have an internal memo that if you're working for X, Y, or Z insurance company, the way you have to write your descriptions, they don't like the word research, but they do like the word analysis because the program catches it. You need to be really aware of those things, because if you put research and then they ding the firm and say, we're not paying any of those bills, your partner's not gonna be happy. The accounting department's not gonna be happy for the appeal that they're gonna have to then go and pursue. And so every firm has some sort of guideline, rule, and definitely deadline by which you need to enter it. So pay attention, follow those rules, and enter those times according to those rules. And that's how you'll survive with your partners.
And you can go off cycle in billing too. This is another thing. Sometimes, I mean, when people are having cash flow periods, that you can bill certain amounts every 2 weeks. You can do selective clients and do that, but you don't have to be that regimented. Again, big firms may have a policy that you have to stick to. Although I would suggest maybe going to the partner and saying, hey, we just want a great summary judgment motion. I know it's mid-month, but maybe now would be a good time to send out a bill and explain while the client's really happy, you did a good result, instead of waiting, because look, if you do work on January 1, when do you get your pre-bills back? Probably the first week sometime in or mid-February. You adjust them, you do that, they go back, then they send out the client. I mean, the payment doesn't come in for sometimes 2.5 months after you first provide the services. But to my point, if you've got strike while the iron's hot. If you've got a good
don't let your
result,
big win wear off.
yeah, they forget about that. Okay, so where are we going next? What's happened now? Hey, savor the victories when you get it. Clients are excited and they want to thank you for a good victory. So that's a good time to generate a bill.
And you can also foresee some of these things coming. If you look at your calendar and you can see when you have a mediation on calendar, you prepare, make sure time's entered, you get the updated bill before you go to that mediation. That way you make sure your fees are paid or the proceeds you're receiving are paid to your attorney-client trust account. Those things, you can foresee this coming. And as an associate, the expectation is that you should be looking at these things. Right. The partners have a lot more cases that they're overseeing, and those are the details that make you valuable within your partnership. And those are the things when you make sure you get that bill paid and it's easier, people appreciate that. Yep. So follow those guidelines, pay attention to those things. The last slide, because I know we're here at the hour. Thanks for spending an hour talking about billing with us. John and I have our emails here on the end slide. I'm happy to send a copy of this PowerPoint. Or if you have other questions, John's got 35 or more years now of experience. And I have kind of my own take on things that I've learned from John and other partners as well. So either one of us are happy to answer those questions for you.
Super.
I don't see anything in the chat or Q&A, but if you have anything, feel free to email here. Same if you end up watching this recording on InReach later, always feel free to reach out to us.
Yeah, thanks for taking the time over the lunch break to hear something dynamic billing presentation as opposed to, this area of the law. But again, a big part of the practice, you just gotta be, and it'll save you time. And then you can focus on what you really enjoy. You're not going to be dealing with client concerns about, this charge or that charge.
That's right. Nice.
Okay.
Perfect. All right. Thank you.